Order, order. Thanks very much for coming along. This afternoon we will now hear oral evidence from the Law Society, the Bar Council, the Family Mediation Council and Leigh and Co. Solicitors. So for the record, would you please introduce yourselves to the committee?
My name is Leigh. I'm President of the Law Society.
My name is Peter Lodder. I'm the Chairman of the Bar Council.
My name is Claire Pizan. I'm a partner in the firm of Leigh and Co.
I'm having some difficulty hearing. I don't know if it's the acoustics, but if we could perhaps in future maybe speak a bit louder would be extremely helpful. But before calling the first member to ask a question, I should like to remind all members that questions should be limited to matters within the scope of the bill, and that we must stick strictly to the timings in the programme motion and the committee, which the committee has agreed to already. And I sincerely hope I don't have to interrupt people in mid-sentence, but if need be, I will. So. First question is Yvonne Silva.
Thank you, Mr. Chairman. I think the Bar Council today have issued a report that said it's do-it-yourself justice. Can you tell me what impact you think there'll be on the courts over the numbers of litigants in person? And what about the vulnerable people who can't represent themselves?
Well, we have indeed made such a statement because what I hear from young family barristers is the danger of serious damage to the safety net for children, vulnerable people and hard-working families. And what I hear from judges in busy court centres, already busy court centres, is the significant risk that those people who will now be forced to conduct their own cases, in other words, litigants in person, will clog up the courts and will dramatically increase the costs of the system. And this is, in our view, a very serious and worrying prospect, particularly because amongst those who I speak to, and they're not just other members of the bar, but they are judges, they are interest groups, they're members of the public who write because they share our concern for the interests of justice, there is huge scepticism amongst that group, wide group, that any savings will in fact result from these cuts. So vulnerable people's positions are going to be compromised. People are going to be forced into a position where they have to act on their own behalf in alien surroundings under conditions of great stress, and we think it will cost more.
I think what should not be forgotten as well
is that these civil cost proposals will also impact on Middle England, and you will see a group of people who have hitherto had access to the courts denied access to the court because they will not have assistance. And anybody faced with a difficult and complex case to bring will have difficulty dealing with that themselves.
Okay. Just before calling the next member, I believe you're joined by the Family Mediation Council. Just for the record, could you perhaps introduce yourself?
Yes, I'm Deborah Turner, convener of the Family Mediation Council, which is a council of the professional bodies for family mediators.
Okay, thank you. Mr. Robert Buckland.
Thank you, Mr. Chairman. It's really a question to Peter Lodder primarily, but Linda may be able to help as well. And I should declare an interest as a criminal legal aid practitioner until the election. It's been suggested by some quarters, including the party opposite, that more savings could be made in the field of criminal legal aid. We come to this bill after many years of, shall I say, retrenchment in criminal legal aid. What do you say to the proposition that more cuts can be made in that area?
Well, let's look back to the last day of the last administration. I'm not in the business of putting one party against the other, but the reality is that on the final day of the last administration, criminal advocacy fees were cut by a standing order, by a statutory instrument, which cut fees by 4.5% successively over 3 years, a total of 13.5%. On top of that cut, there are many cuts here which will see, for example, the fees paid in murder-manslaughter cases being cut by yet another 25%. So we're talking about nearly 40% worth of cuts over a very few years. This against a background when there has been no actual rise in fee income for in excess of 15 years, because fees have been frozen over that period. I'm not pleading for more money, but I am saying that you are cutting us a lot already.
I think it's well known that we have put forward a raft of alternative proposals, and we would invite the government again to look at those proposals and perhaps look at them in more depth than has previously been considered, because we agree that savings have to be made, but we think savings can be made without impacting directly on the vulnerable, because I think Peter would agree with me that what our concern is not really about lawyers involved in this. It's a very tiny percentage now of solicitors in England and Wales involved in legal aid work. We're interested in the impact on the clients who need this help, and I think we can say we're united on that point.
Absolutely. Carol Turner.
Thank you very much indeed, Mr. Sheridan. I have to say to you, panel, I've had longer to cross-examine witnesses for a very simple road traffic offence, someone parking on zigzags, and I've got to take evidence from you today. So I will try and be quick now I've made that point. I've got some concerns in relation to the definition of domestic violence in the bill. I wonder if you could help me with what impact that will have from a practitioner's point of view, please.
Well, we have suggested that the definition used by ACPO, clearly an authoritative definition, is the one that should be used. The government has chosen not to do so. It's chosen what appears to be a narrower definition. Obviously, we don't know exactly what that will mean, save that it must be that fewer people will fall within that definition, and therefore fewer people will be eligible for what little legal aid is left. The problem is further increased by the fact that now, absent domestic violence, you will not get legal aid. So if a client presents at a solicitor's office on the back of a matrimonial dispute and is asked whether there is any evidence of domestic violence, and they are aware of the fact that that's the only way that that person will get legal aid, then there is a strong incentive to say that there is indeed violence. So the problem compounds, because then if that allegation is made, first of all it has to be investigated. That will bring in other authorities at greater expense. But in addition, assuming for the moment that it is a false allegation, although the person making the allegation will get legal aid, the perpetrator, as alleged, will not. And so in court, someone who may be facing a false allegation will have to defend probably himself against the allegation, risking losing everything. Children, liberty, home, you name it. And they will have to defend themselves in that circumstance. We do not see how that can possibly advance access to justice.
I don't know if Linda Leigh can add anything to that.
I don't need to add anything from a practitioner point of view, but I would add, as you well know, that from the government's own impact assessment, this will not bring in huge numbers of cases, which should probably be brought in to protect, for the majority, women and children. All of these proposals impact disproportionately on women and children, and this is a particular example.
Okay. Ben, go on.
Thank you, Mr. Chairman. It's a right to serve under your chairmanship first time. Mr. Loller, how many barristers travel first class railway?
I have no statistics, but I can tell you I don't.
Yeah, I've never heard of any travelling first class and charging it to the taxpayer.
No.
What would you say to the suggestion that £10 million can be saved by limiting all but essential advocates' travel to court and hotel expenses and no longer pay for first class travel?
Well, I've already said that I don't know to what extent that is used. I doubt very much that it is.
But that's the suggestion of your neighbour. in her cost savings.
Well,
what do you suggest to capping fees?
I think it's a slightly unproductive process to invite me to enter into a battle
But you've just said you were united, so I just want to check the degree of union. What to capping fees of £250,000? Do you support that as an idea?
Forgive me, I don't want to appear to be arguing with you, and I certainly don't want to appear to be arguing with Linda Leigh. The point here is that we are united in asserting that the proposals that the government has set down in this bill are deeply harmful to justice. If you want to trim around the edge on travel costs and the like, then perhaps you might find it a profitable line of inquiry. Personally, I wouldn't. We know what we agree on, and we agree on the fundamentals.
I just want to explore the Law Society's other savings they've been trumpeting, because as far as I can make out, about £42 million come from the bar, already under considerable pressure in criminal cases and family cases. Is that something that you have discussed at the Law Society?
Well, I know what they've said. I don't particularly agree with them, but I'm not going to have that spat publicly here.
So that's £42 million that the Law Society proposes.
I don't accept what they said, but I'm not in a position to argue it here.
Thank you,
If I could I help? We have relied on
information provided by the LSC, and I think your question is probably more properly directed at them.
Well, it's not. I just wanted to check. I just wanted to check what the bar thought of your proposals to trim £42 million from their fees. Thank you.
Okay. Kate Green.
Very much, Mr. Sheridan. I wanted to ask a question specifically of Claire Kazan from Leigh about the impacts that you think the reforms will have on civil litigation on cases like Trafigura, which obviously your firm very famously pursued. And I wonder if perhaps it would be helpful for the benefit of the committee if you just explained a little of the background to the case as well.
I'm sorry, there has been a misunderstanding. I'm a clinical negligence specialist. That's my area of expertise. That's the area in which I'm afraid I've come prepared to answer questions.
Is anyone else able to comment on that case or the impact of civil litigation?
I can talk very vaguely about it as a person within the firm, but as I say, I haven't come prepared because I'd understood that this was going to be about clinical negligence, which is my area of expertise. What I can say is that it will make it very difficult indeed for the big group cases to be run where it is expected that costs are going to come out of compensation and where there is a proposal that there is not going to be any insurance. Beyond that, I think it's slightly difficult for me to go into any further detail without a bit of further preparation.
I could answer in general terms, and in general terms, these types of litigation are being hit twofold. On the one hand, the availability of public funding will be gone. On the other hand, running cases on a no-win, no-fee agreement for risky, difficult or complex cases will become increasingly difficult and unlikely to occur. So that is our broad position on all types of litigation, and that will impact on a whole range of people.
Okay, Jonathan Thorpe. Just on the same issue.
We just try to explore effectively the impact of the success fee. On both Trafigura, my understanding is the legal costs for that case were 100 million.
I'm sorry, I can only deal from my... I've come prepared to deal with clinical...
Okay, no, I can tell you the facts if you want about the costs, because I'd like your view on the success fee, which is relevant both to clinical negligence and other parts of the law.
I'm very happy to talk about success fees in clinical negligence cases.
Okay, I use but the success fee is a more general concept. It's not just confined to clinical negligence. It's about whether you think the success fee as a principle needs reforming, as Jackson, Lord Rupert Jackson's view tried to clearly, or Justice Rupert Jackson tried to change. So the success fee in Trafigura was, well, not the success fee, the legal fees were 100 million, the awards were 30 million. In the Naomi Campbell case with the Mirror, her awards for damages were £3,500. The legal fee award was 1.4 million for that. The success fee made up nearly 50% in both cases of the legal costs. What is clear from, for example, both cases, that the success fee, as is in many other cases of success fee, is not shared with the claimant. It's shared by the lawyers to compensate them for failing cases elsewhere. I mean, that's the principle of the success fee as it was changed, the latest in 2003, to compensate them for other failing cases they might have elsewhere and to close the risk. Yeah. Well, I mean, Mr. Turner, you weren't here at the beginning of the session this morning, so if you listen, you might learn something.
Ben, carry on, and we'll try and get a question and get an answer here.
On the success fee issue, do you think that it is okay for defendants to pay excessive fees to compensate lawyers for non-performing cases they may or may not have against other defendants?
I'll deal with part of that. The crucial thing in terms of limiting the costs of civil litigation is in terms of dealing with litigation behaviour. The concept that has been proposed by many people in the context of these reforms is that there should be fixed success fees which are tied to stages of litigation and which are designed to impact upon litigation behaviour. Therefore, that there is no success fee payable in a case where during the pre-action protocol period there is an admission of liability. The defendant shouldn't pay anything then. If there is then an admission of liability at any stage up until the key trial preparation is being done, which is usually talked about as being about 4 weeks before trial, then there should be a success fee, but not the sort of success fees that people are talking about in the press of 100%. A limited, structured, fixed success fee. It is only when a case is litigated by defendants to trial or to immediately before trial because of delays in dealing with settlement of cases that then the 100% success fee comes in. Now, in the field of clinical negligence litigation, that is a typical pattern, that it is only at the last stage that admissions are made, cases are settled. Very, very few cases go to trial. They are settled very late in the day, and this is regardless of how they are funded. And it is those cases that are taken until the very late stages or to trial, where it is entirely proper, where a claimant then succeeds in proving what would have been the subject of an admission, or is indeed the subject of a late admission, that the claimant should recover the success fee.
Could I add to that? Because I agree entirely with what Claire said. But what you have to remember is it's very dangerous to look at one case, pick that one case out and say, that doesn't sound right to me. Because what you don't know is all the circumstances of that case. But the answer is that the court judges the circumstances of that case. The court, on request of the paying party, can look at the bill, look at the success fee and decide whether or not that was appropriate. And if the court feels it wasn't appropriate, then the court marks it down. So there is a test to establish whether or not it's a fair fee. And the second thing is you only hear about the cases where the defendant has lost, and as Claire said, the defendant has chosen to pursue that claim to trial, and you have to question why in many cases.
Well, very briefly, Ben, and very brief answers as well.
Look, I understand when a defendant loses, he pays compensation. He or she pays for their failure in whatever field. It's the extra bit, it's the success fee, where that defendant then pays for some other failing case elsewhere, or to compensate the lawyer for taking on cases in other fields. I understand that the people culpable should pay for the mistake they make, and they should make reparations, etc. It's the extra bit, as one of the big law firms on their website said this morning, described it as a wing bonus that went to the lawyer. I don't see why that principle is fair.
The purpose of it was entirely because you take on a risk. As a solicitor, if I was running a spread of clinical negligence cases, I would look at how much risk the firm could stand. And to take on more risky cases, there has to be a fighting fund. And yes, you're right, that was the original principle. But the award isn't simply about giving you a fighting fund. It's far more complex than that. And when you set up a CFA, you have to notify the other side that you've entered into it. You have to provide information to the court, as I said, as to how you arrived at that figure. You don't simply say, I'd like 100% please. You've got to explain the risk, the levels of risk, and also the defendant's behaviour in that is looked at. And the defendant has opportunity to settle at earlier stages. The defendant generally has the knowledge and information and has that opportunity. But the proposals in the civil cost part of the bill are to say that the defendant should take no risk, no responsibility for their behaviour, and instead it should be the injured person who does that, because you're talking about not recovering that element from the defendant, you're talking about recovering it from the claimant. And so the claimant does not get 100% compensation for the injury they have suffered.
Okay, this is an issue we may return to if time allows. Dave Watts.
I think it's generally accepted that the government's proposals will reduce the scope and reduce the amount of people that will be eligible for legal aid in the future. That would then leave a gap in the justice system, which the government seems to think they can fill by mediation, or one of the mechanisms for mediation. First of all, are there enough mediators around to do this? And secondly, in your view, is mediation a substitute for court action?
Well, I will answer first, and then I think Deborah should come in after me. But mediation is a very good tool in any litigator's armoury. But the point about mediation is it has to be used at the right stage, in the right case, in the right way. And you can't simply say, it is day 3, we will now apply mediation, or it doesn't work. And the most successful mediations, as with the most successful court actions, are where parties have been properly prepared, so the issues have been narrowed down and time is saved, so people are ready to settle. But on the question of numbers of mediators, I think Deborah will...
I can only talk about family mediation, but on family mediation, numbers are increasing, is what I could say. Yes, there is a potential problem about capacity. There's no point in pretending that there isn't. But the pre-application protocol, which came into force in April, requiring privately funded parties to attend an assessment meeting, has meant that there's a good deal of training going on at the moment. So numbers are increasing.
What will happen in the cases where they've been referred for mediation and that mediation fails?
On the subject of family...
How will it be brought to a fruition? How do you end the process?
On the subject of family mediation, if the mediation fails, it breaks down, then... But normally what would have happened was that the parties would return to their solicitors. But there is going to be a void. And it's a great worry, and we are worried that it will put undue pressure on mediators to keep cases going, to keep mediations going after they've actually ceased to be sustainable, and also pressure on assessing the unsuitable as suitable in the beginning, because we are very well aware that parties are going to have nowhere else to go.
A very important point here. Mediation is available to people who come to it with a desire to mediate. And the current situation is that they have to go through that process, but they approach it having been advised, and they approach it with the support of the advice that they have given to know what that process is about. They're much more likely to engage upon that basis. Where they're told they've got to go into it, they don't have the support of any structure around them, and they go into an alien environment, forced to do something they don't, or at least one party will not want to do. That will simply inflame the situation, which then spills out the other side into litigation. Under these proposals, that litigation also will not be supported, and so you have people who tend to be at one of the most stressful points in their lives, and therefore pretty unlikely to accommodate the needs of the person who's causing that stress, in face-to-face contact with no one between them and no safely consensual outcome.
May I just add something?
Briefly, Claire, so
I will be very brief. In my field of clinical negligence, we have a requirement from the court that there is alternative dispute resolution at a particular stage in the case. The vast majority of clinical negligence cases that are settled after the pre-action process, which is before we've actually issued proceedings, are settled through an alternative dispute resolution process, whether formal mediation or another form of mediation between lawyers. That is incredibly useful, but it can only be done when all of the evidence is available to everybody, which is inevitably a later stage within the case. So it's litigation that leads to mediation or alternative dispute resolution.
Okay. Very, very briefly.
The problem is that there will be nowhere for these people to go, and the cost will be picked up by other agencies downstream. Then there will also be a social cost, and that's unavoidable.
Okay.
Can I just add that I think that we feel that there's a very real danger that those cases which cannot be resolved into mediation, family mediation, have nowhere else to go. They will end up in court, and you will have some very, very stressed out litigants in person.
Okay. Elizabeth Truss.
Thank you. I just want to return to this issue of the scope of legal aid. Isn't it the case that in other countries with similar legal systems, such as Canada, New Zealand and Australia, there are much lower costs per head of legal aid, and also the scope is much narrower, and the eligibility for legal aid is much lower? So my understanding is, roughly speaking, it's around £10,000 income, and then you don't receive legal aid in those countries. So isn't the British system pretty generous in terms of the eligibility for legal aid and the scope that is being proposed under this bill?
No, sorry.
Well, what could you comment on those specific countries?
I certainly
please?
can. I think we've made it quite public, our views on this, that a lot of the jurisdictions referred to don't use an adversarial system. They're using inquisitorial.
I've just mentioned 3 that do.
I will come to those, but first tackling one by one. Inquisitorial systems spread the cost elsewhere.
Excuse me, I didn't ask the
If you're
questions.
comparing New Zealand, I think the figure you have quoted is £8 per head. We know that figure is vastly out of date, and it is probably at least double that cost now. But you're talking about a rural population of approximately 4,000 people, and you are comparing that with the problems we have here. If you look at France and you look at the figures
I didn't mention France. I asked you specifically about the income eligibility in New Zealand and Canada. Could you answer that question?
What you are looking at is a totally different set of social circumstances, and you cannot compare you're not comparing like with like.
Well, can you tell me what the income threshold is in those countries?
I will be happy to provide it in writing after this meeting. I don't have it now.
Could I put it to you, the Law Society hasn't actually studied those systems and hasn't studied how those work?
Yes, we have studied those systems, and we have provided this information in detail in the past, but we will resupply it to this committee happily. I would also draw your attention to the Foundation for Change document about British Columbia, where similar proposals were enacted there and changes were made to legal aid, and the impact that has had on the system there. And I will send you copies of that also.
Do you know the income threshold for British Columbia?
No, I don't. But
because
I
have looked at the Canadian system, and I believe most of the provinces in Canada are around an income threshold of about £10,000 a head.
And what are the average earnings, and what are the other social circumstances that
well, when you look at the
about?
British system, where you can get legal aid on incomes up to about £30,000, there's a vast difference.
The threshold of no contribution is income support level. It's a very low level in this country. There are contribution of a sliding scale going up, and I doubt 30,000 unless you have huge family. But it's a complex system. The fee structure will be happy to supply you with it and any other information you want. But you are not comparing like with like, and you are not looking at the facts of what you're actually doing here, because you will have an impact here that it makes no sense. And don't use figures that do not compare. It's a wrong way to justify your position.
But it seems to me that I've put figures to you, and you have not put alternative figures for those other countries.
I don't think you really expected me to come with the means test for every country in the world to this hearing.
But you will provide us with the figures.
I would expect, given that those are the most close comparators to the British system,
I'll provide them.
That you would have them.
Okay. Elfyn Wood.
In this committee before long. Could I possibly take the witnesses back to clinical negligence, something I'm interested in. I declare an interest as having practiced in family law and crime for many years, both as a solicitor and member of the bar. But in particular, the removal of a civil aid certificate where clinical negligence has occurred. In very serious cases. I know the government have rolled back slightly and said that some there be some cover for initial medical reports, which I appreciate are crucial. Overall, what's your view on that? And I'm asking Mrs. Ann to begin with.
Well, first of all, I'm not quite clear what the rowing back is. There appears to be a suggestion that there will be some prescribed cases which may fall into exceptional funding, but it's very unclear what the requirement for that would be. But just moving on, let me just talk about the profoundly brain-injured children cases, because I think people have an assumption that it is very easy for somebody who specialises in the field to know the minute somebody walks into their office that there is a claim that can be run. I wish that was the case. I can only think of one case in 24 years where I have been confident. And the reason is that the claimant has to prove the case. The information is in the hands of the health providers, both in terms of documents and witness evidence. Witness evidence isn't available till well on into the litigation, by which time you've had to actually say what your case is. Most often I'm faced with unsophisticated, by which I mean not professionally, medically trained people who know they've got a baby who, shortly after being born, they have been told is unwell. Imaging shows that the brain is injured, but they don't know why. In order to work out whether that is the result of negligence, I need a midwifery expert and an obstetric expert. To know whether the negligence would have avoided the injury, I need a paediatric neurologist. I may have to organise brain imaging. I need a neuroradiologist. I need a fetal-maternal expert. And I need quite often I will need other people like geneticists. It is only when I've got all that information that I can say to my clients, you have a case which I think has reasonable prospects of succeeding, not certain. That is going to be very, very difficult for those families who are devastated and who put all savings on hold, all family plans on hold, often won't have further children because they can't risk the thought of coping with other children. They are then going to have to find lawyers now who will say, we can take on this case, knowing that at this stage we have no idea whether we can win it. We have no idea how we're going to fund the costs of these reports. There may be some sort of after-the-event insurance at the end of the day which may pay for it, but how's it going to be paid along the way? Those are big costs for lawyers to have to carry. We know from the impact assessment that small firms are not going to be around to carry these. They're going to be difficult for any firm to carry in any sort of number. And so I'm afraid the answer is it is going to be reduced access for justice for the most vulnerable people within our society.
Can I add on that? There is an important role that clinical negligence litigation plays. And in an ideal world, this wouldn't be the case. But it does impact on patient safety. And with less cases being brought, which we think is fairly apparent from the proposals both to removing legal aid from scope, other than exceptional cases which we know not what they will be, but also the Jackson proposals, which will stop a large number of clinical negligence cases being brought, but probably won't impact on smaller Valley Road traffic claims. You will see a corresponding drop in probity and consideration of problems arising from medical accidents, and that's vital to society and to improve patient care.
Thank you.
I think if I may add to this, it's important to note that when Lord Justice Jackson produced his report, he envisaged there would be a legal aid safety net. Yeah. Conditional fee agreements came in because of the withdrawal of legal aid. If you take then conditional fee agreements out, or at least reduce them to the extent that they're not available to people, then if you don't replace the legal aid that they were there to replace themselves, there is no provision.
Is this on the same issue, Ben?
Yeah, it is.
Okay.
I think you said earlier that what's very important is early sort of disclosure, early sharing, certainly in perhaps clinical negligence cases. Would you be supportive in the NHS LA being much more compelled to perhaps share much earlier on reports, etc., in cases where you try and resolve things before perhaps getting to court or getting further down the line?
I think one of the proposals of Jackson was that there should be earlier sharing of evidence, and that has improved, but it still doesn't address the basic problem that Claire addressed, which is the causation issues. which are very complex, and that's why you have the real difficulty in assessing whether or not a claim is going to be successful, and also the value of the claim.
May I just give you one very small example? It is now often the case where an adverse incident has occurred, something unexpected has happened, that there has been a hospital inquiry. I may, at an early stage, get a report from the trust itself, which has carried out an investigation, and they may well say in there were failings in care. But the problem for me is I have to be able to show that intervention, when they say it should have been intervention, would have been in time to avoid this devastating injury for the individual and for the family. And that is not something that is going to be investigated as part of the treatment of my client. It's not necessary for the treatment. And so it's an investigation that happens only due to litigation. In litigation, we do exchange reports very early on. And we do now, thanks to cases that have been cited over the years, have this sharing of information. It is a very efficient system, our litigation system for clinical negligence.
Okay, Andy Slaughter.
First question to Linda Leigh, or any others may want to answer it. But we've taken the approach to this bill, particularly the parts on legal aid, that this is essentially a cost-cutting measure without a view to the social costs or access to justice. But the Law Society, I think I might have said it in evidence, that it believes that the actual cost of the public purse will be higher, i.e. there will be increased costs. Could you explain that?
It's quite simple. All of these decisions, if you have early intervention of problems, and the CAB and others have produced figures on actual cost, downstream costs, all of these proposals will not make a problem go away. What they will mean is that the problem isn't dealt with at an early stage by lawyers trying to resolve matters, or possibly not lawyers, possibly not for-profit agencies. This isn't all about solicitors. But that early help won't be available. So what happens to those people? What happens to that problem? Do their children end up in care? Are there costs to society? All of those problems will happen, and so we very much feel that you're simply shunting the cost away from the legal aid budget to somewhere else, and that cost will be greater. And there are studies that have shown that is the case. The government's own impact assessment suggests that will be the case. It's so obvious, I can't think what else to say.
Well, can I just put it into a slightly narrower context, and that is in the context of family breakdown. In the midst of a family breakdown, in most cases there are children. One parent is not going to have custody of those children. Often when these cases come to court and lawyers are involved, the parent who looks least likely to get custody of the children will be told in no uncertain terms, you're not going to get them, and what's more, fighting it out in the courts is likely to make the situation worse. These people are not always at their most receptive at these times of stress. But they do eventually listen to what is said, and many cases are in fact settled without the need for going to court. And there's plenty of evidence to support that. The Council of Circuit Judges, for example, have given clear evidence about it. But if these people are representing themselves, there is no sensible whisper into their ear. And in fact what they do is they go into court and things are said, one against the other, which make the situation more difficult rather than less, and on it goes. And the person who feels they should have custody of the children doesn't get it, and feels that it is a question of fighting harder and longer, and that is what they'll do. You'll clog up the courts, just as I said earlier, and just as many other authorities have said.
May I add one other thing to that in the context of clinical negligence? Of the cases in which legal aid certificates have been granted and there has been the pre-action investigation, it is recognised by the LSC and I think the MOJ, as well as it being reflected in my practice and that of others, that about 50%, slightly more of those cases, are not pursued at the end of the litigation, at the investigation. And that is because lawyers are taking a view that this is not a case with reasonable prospects of success. Those are precisely the cases, if they fall out of the legal aid scheme, that people will be struggling on their own with, and they will be clogging up the courts, whereas at the moment they're not.
Sorry, excuse me, just one thing, if I may. I should have referred to the Family Justice Review being conducted under David Norgrave. They produced an interim report recently which speaks specifically about the value of legal advice at an early stage to avoid protracted hearings.
breakdown, that mediations are conducted with the mediator not giving advice. They must not give advice. They are there they can give legal information, but not give advice. But they are confident that there is the availability of sensible legal advice for their clients. And mediators would feel extremely uneasy conducting mediations in other circumstances. It is very important for those clients to be able to go and take their legal advice and to know that the decisions that they come to are sensible and legal.
Can I pursue a point with Deborah Turner? I mean, I think probably all parties here would agree that mediation, if possible, rather than an adversarial solution, it would be good. But do you feel, in looking at the proposals here and the costs involved, A, in terms of ensuring there are an adequate number of properly trained mediators, and B, in dealing with all situations without the backup of litigation, including where there's an inequality of arms between the parties. Do you ever feel that you may be being set up to fail here because so much is being put on to mediators to resolve litigation?
Mediators, family mediators, are extremely concerned about these proposals, yes, and we can see huge pressures on mediators, not least the expectations of the clients who haven't had the legal advice that's so vital, as was said at an early stage. The big risk that they will come to mediation expecting the mediator to be able to solve all the problems. Tell them what to do, write it all up. Mediators are not trained to do that, nor should they be.
One final question I made to Claire Fazan principally. You said something about clinical negligence. What is the landscape going to be in clinical negligence if all the provisions of this bill go through? Because we've heard about the double whammy in terms of removing legal aid from scope and the changes to CFAs. I don't know whether you undertake both. But how would you now deal? If you had one of the types of cases you talked to us about, a parent coming to you with a catastrophically injured child after the provisions of this bill have gone through, if they do go through, how would you be able to advise them, and how do you think your practice will have changed in the light of that?
Well, there is another big question, because there were recommendations in Lord Jackson's report which have a major impact on how these reforms may or may not impact on this field of work, which is the issue of qualified one-way cost shifting. And until we know what's happening there, it's very difficult to know, because at the moment, as I understood it, his proposal was that there would generally, the defendant's costs would not be paid by a losing claimant except in qualified circumstances. At the beginning of the case, I have to tell my client, I don't know what these qualified circumstances are going to be and whether it's going to affect you or not. And the only prudent claimant, therefore, and prudent lawyer will say you need to take out after the event insurance. We don't know what the after-the-event insurance market is going to be in this brave new world, whether in fact it's going to exist, whether it is a commercial market that can last. So the answer to your question is partly I don't know. The second answer is I will have to take a view based on the caseload that I have, whether this is another case that I can risk exposing my firm, my staff to, or whether this is a case I'm going to have to simply say, look, I'm sorry, I've got too much exposure at the moment, you're going to have to go to somebody else. And then the danger is that somebody else will say the same. And so we have an ever-reducing access to justice for these people. It's not through not wanting to help them.
Okay. Just very briefly, because I've got other people indicating they want to speak.
Yes, it's about the particular difficulty of clinical negligence. The proposals are that there will be a 10% uplift on general damages, which will pay for the success element from the client rather than from anywhere else, and that will be capped at 25%. There are particular difficulties with clinical negligence because general damages are uncertain in personal injury cases for the most part, but they're particularly uncertain in clinical negligence because you're talking about an exacerbation of an injury rather than a pure injury. So when you're assessing the risk at the outset and you're trying to work out how much money your client will get as an uplift, and you are trying to work out where the 25% cap will be, it will be impossible. It will be far harder than in a road traffic case. And if you look at the Jackson figures, where it's suggested that most claimants will benefit, if you take out the simple road traffic cases, then most claimants will not benefit, and most claimants will receive less than 100% compensation. And I think it's important that clinical negligence is seen in that context.
Okay. Tom Bray.
I just wanted to briefly come back to the issue of mediation. I wanted to ask you whether your respective organisations have any proposals about how mediation could be strengthened or enhanced or made more relevant to ensure that more people are diverted from courts, or whether in fact you think that there is precisely the right amount of mediation now and it can't be increased in any shape or form.
Well, speaking from the perspective of the Bar Council, many more barristers now are trained as mediators, and we do see it as a very productive and helpful way of moving forward. You may be surprised to hear that, generally speaking, we don't like litigation, and if you've got to court, something has gone wrong, and so any attempt to avoid that outcome is taken, and mediation is a particularly useful way of doing it. But as I said a short while ago in answer to one of your colleagues, mediation only helps those who really want to do it. You've got to have that mindset, and there are people who do not want to compromise. There are people who want to litigate till the absolute end, and in those circumstances, frankly, it doesn't matter how keen you are on mediation and how many mediators you train, they will pursue their case.
Can I just ask if that process of training barristers in mediation is that complete, or is that an ongoing programme where you'll see more people trained in that and therefore able to take up more mediation than is currently the case?
Absolutely. I mean, mediation is undoubtedly a very good way of resolving conflict. By way of simple example, I recently went to Calcutta on behalf of the Bar Council, where we've been supporting a mediation scheme there in commercial disputes, and it's becoming much more widespread. So absolutely, we encourage it in all areas of law.
I'll just add, mediation isn't new. I qualified in '94, and that was about at the point at which everybody started offering training schemes, because it was recognised as very useful, and the Law Society has accredited mediators for a very long time, so it's an ongoing programme, and we all support the concept of mediation and its use in the right place. But there isn't a magic formula, and I think Deborah will agree that we'll make every case settle in mediation. Some cases
No, I'm
can't.
asking you whether you have got plans, as it would seem that the Bar has, to actually expand the level of mediation training to be able to deal with more cases through mediation.
We can cope with as many people who want to train to be mediators as required, because that has been in place for a long time, that training. But it's not the case that we can magically produce a cohort of mediators who will resolve these issues. These issues won't be resolved in that way.
Right,
so the training is there, the accreditation is there.
There's no way in which more mediation could be progressed.
There's always ways that there can be more mediation, and that depends on the willingness of the parties, and also someone willing to pay for the mediation, which there is a cost to mediation. Mediation is not free, and so probably the limit at the moment as to the number of mediators is the amount of mediation that is available to do. But that doesn't mean you will resolve more cases by mediation. I think there's probably an oversupply of mediators for the current level of work. I'd be interested to know what
Ms. Lauder, could I just mediate just now in the sense that we've very limited time left and we want to move on. Alex Cunningham.
And I want to return to where we almost started, and that was about vulnerable people. The panel have made it very clear this afternoon that the government's proposals to withdraw legal aid for some of the most vulnerable and poor will be quite disastrous for them. The mother who loses her children because she can't afford to fight for them, or the father who can't get access for the same reason. What changes should we be making in committee to this bill to avoid that disaster?
You should restore the proposals to take, for example, family issues out of scope. You should restore a proper definition of domestic violence. You should restore a facility by which people who have suffered injury through no fault of their own can get representation so they can have proper compensation. And you should restore a system which means the compensation they get is the compensation the court has assessed they need. These are the sorts of things you need to do. And we're very happy to provide amendments to help you in order to do that. But the fact is, this bill gives with one hand and takes away with two.
Direct answer to direct question.
Absolutely.
Thank you.
Thank you. Damien Hines.
Thank you, Chair. I wanted to return to the question of the international benchmarks, because it's been a very important part of the wider debate on this subject. And there have been figures quoted in Parliament suggesting there's a huge gap between legal aid costs in this country and some others, including comparable countries with similar legal traditions. I know you'd probably dispute that it's not a direct like-for-like comparison and so on, but even after you allow for all that, it seems there is still quite a sizable gap. So my question to the panel is, what do you believe are the drivers of that gap? I mean, Linda, earlier, you seem to be suggesting that in the case of New Zealand, rurality and the small population were drivers of the difference. Forgive me if that sounds like a counterintuitive response, because those are usually considered drivers of higher per capita costs rather than lower. So I was wondering if you stick by that, or if you think there might be other drivers and differences of cost between countries.
Well, I go back to, I believe in New Zealand as well, there are increased court costs. You're not comparing exactly like-for-like situations. And if you want to do us to do a full analysis on that, we're happy to do that. But you're also looking at different levels of criminality. You have different percentages of population convicted of crime. And I was interrupted when I was saying about France. It's almost double the amount per 100,000 of people convicted of crimes in this country as opposed to France. I don't know the social reasons for that, but if you drill down into the detail, you'll find considerable differences.
But if we can just stick with countries that are broadly comparable in terms of the legal tradition, so exclude France just for the moment, what do you think are the key drivers of differences in per capita cost of legal aid between countries, which even after you make the adjustments that you've been mentioning, it seems that this country is still a particularly high cost country per capita?
The countries you're talking about as being similar, I assume, are Canada, New Zealand and Australia. Well, I don't think anybody would suggest that the social setup in any of those countries is in fact comparable with this country in terms of the levels of crime, the levels of social deprivation and the needs of society. I think there are significant differences.
So what are the main ones that would
Well, New Zealand is a place where they have a very low population and they don't have, for example, a moss side. They don't have serial killers as we do to the same extent.
But how much the legal aid bill is serial killers and moss side?
Well, these are aspects that impact on how much you spend. Can I just take you to something else? You've moved away rather sharply from the comparators that were being used by the government with other European countries. And one of the reasons why the government has stopped using those comparators is because the Council of Europe has said that our legal aid costs are average in Europe. Let's compare European countries, shall we? They're more like us than perhaps New Zealand is. And also the Legal Action Group in this country, not a lobbyist for lawyers at all, have said our costs are average for Europe. That is their finding and their research. I haven't seen any particular research which goes into the detail of this on the government side, in the way the Council of Europe has or the Legal Action Group,
excuse me, could
to
I
the same
just,
degree.
We're coming near a time. I think this issue has had a particularly good hearing. If you could provide an analysis of comparison countries or other European countries, that would be extremely helpful. Helen Goodman.
Thank you. I want to go back to the questions about private family law. I'd like to ask Deborah Turner in particular. You spoke very briefly, you mentioned the fact that in cases of mediation, quite frequently one party has more money than another party. Do you think that withdrawing legal aid so that people come without having the benefit of advice will particularly disadvantage women and children as opposed to men in these situations?
Well, it has to be said that it's very often the wife who is legally aided, and so if you're, I mean, the answer to your question must be yes, there is a big risk.
So that being the case, what would the risks be to women and children as opposed to men in these situations?
Well, the risks, particularly in financial cases especially, very often the wife may, particularly the wife without income of her own, has not had very much financial experience. She doesn't understand how the finances work. It's a mediator, it's part of a mediator's professional duty to make sure that she does understand it, but she very much needs the backup of sensible legal advice to tell her what is in her best interests, which a mediator cannot do. And that's extremely important. A mediator can tell her what the position, the legal information is, but they cannot advise her as to her best interests.
Do you think the bill could be amended to ensure that litigants in person in private family law cases are not able to cross-examine either children or other adults whom they are alleged to have abused?
Well, I don't see how you can do that, because who's going to ask the questions? I mean, if there is, in every case, there are questions to be asked so that evidence can be contradicted and evidence which suggests that an allegation that is being made is false. But if you can't ask questions of a witness because the only person available is the person who's accused...
Order. We have now come to the end of the time allotted for this particular session, and it's just on behalf of the committee, could I thank all the witnesses for coming along. We now move on to our next oral evidence, which will be from the Director of Public Prosecutions.